Okay. Okay, let's see. Would you please get Michael O'Donnell and Leela Daigle? Both of those for Ms. Peraza.
Hello, Judge. Good morning.
Good morning, Mr. Peraza. The bailiff is going to get your clients. Just hold on a minute.
Okay, yes, sir.
No, not nearly that easy now.
This is cause number 327504. Case is filed in the state of Texas versus Michael Billy Wayne O'Daniel. Is that your full name? How you doing, Mr. O'Daniel?
I'm doing better. How are you doing?
I'm doing fine. Thanks for asking. Mr. O'Daniel, you're here represented by your attorney, Ms. Lori Peraza. Ms. Peraza, how are you doing?
I'm doing well, Your Honor. Thank you. How are you?
I'm fine. Thanks for asking. Could you check and see if he has some bond conditions in there? Okay. Ms. Peraza, Mr. O'Daniel case is set on the court's announcement docket. Do you have an announcement you'd like to make in Mr. O'Daniel's case?
Yes, sir. I have almost reviewed his DVDs. We've gone through his paper discovery. It looks like I'll have to make a public information request with the police department, Beaumont PD. And so I need at least 60 days, Your Honor, so I will have sufficient time to get those records and get them on file if necessary,
Okay,
if that would be possible.
okay, just hold on for your reset date. They're gonna reset it to December 1st of 2021.
Yes, sir.
Okay. Now, Ms. Peraza, your reset will be sent to you. Mr. O'Daniel, you can get your reset by standing on the 4X over there. And once you get your reset from our court coordinator, you'll be free to go and you have a blessed day. Okay. And Ms. Peraza, your reset will be sent to you.
Thank you, Judge.
Okay, we're in session and cause number 328512, State of Texas versus Leela Lorraine Daigle. Oh. Your full name is Leela Lorraine Daigle. How you doing, Ms. Daigle? You doing okay? Okay, Ms. Peraza, what is your announcement in Ms. Daigle's case?
Your Honor, so I have had an opportunity to meet with Ms. Daigle, and we have started the review of her discovery. We just recently got her DVDs yesterday, and so I would need sufficient time to finish reviewing her discovery. So if we could have this case reset to your next announcement docket, I would appreciate that.
Okay. What is it, December 1st? Same date as the other one? Now, Ms. Daigle and Ms. Peraza, the bailiff have just informed me that apparently there's a warrant out for Ms. Daigle. I don't know, at this point, I don't know what it is. Mr. Bailiff, what is it? A new case has been filed. What case is it? Case was filed August 25th.
Okay, what is the charge?
What is it? It was a DWI with an open container.
Okay.
Okay.
Okay, so this would be a new offense date other than the current?
That's what I've been told. Okay, the first offense was what, in November 20? And the second one is when? August 25th of what year? Of this year?
Well, the offense was October 8 of 20. You know, the other one came before that one.
Say that again? So it was two offenses. Both of them was in 20. One was in November of 20. That was the one that was filed first. And the second one was in October of 20.
First one was offense date was November 7th of 2020. Then
The new case that was filed.
October 8 of 20. But they followed the one that she put forth on.
They filed the latest, the last case first.
Interesting.
They had two cases a month apart. One in December of 20, the other one is in October 20.
Yes, sir.
They filed the November 21st, and then they just recently filed the October 20. I
That's
don't know.
Okay.
Yeah.
Okay. Do you know what her bond will be set at?
Well, she's taken into custody. I'm gonna have to review the bond on it. She may have, she have two DWIs. So I can just tell you right off the bat that one of the bond conditions is she's gonna be required, if she doesn't have one, she's gonna be required to have an interlock.
Yes, sir.
She got two pending DWIs.
Yes, sir.
But I'll review the information to set the bond. And so the bonds, the bailiff is gonna take her into custody, and then once we finish with the docket, I'll get the information to set a bond. Okay?
Yes, sir. Thank you very much.
Okay, now I guess, let me do this. Okay.
Your Honor, could she be released?
What did you say?
Well, Your Honor, is there a way that she could be released today or have the conditions imposed while she's here before you now, and then give her
What
an
you mean
opportunity
released?
to comply with that today with the interlock device?
Well, she has to be taken into custody. There's a warrant out, so the warrant has to be executed.
Yes, sir. I understand. Well, could I go ahead and make a motion for a reasonable bond of at least 1,500 or lower?
I'm gonna look at the, we're gonna look at the facts of the
Yes, sir.
case. What I was gonna do is just have her to take a seat in the jury box, and then we can get back to her later, and I can get some additional information, the information that I need to set a reasonable bond.
Yes, sir.
Okay?
Okay, thank you, Your Honor.
All right. Just have a seat in the jury box. Okay.
And I assume, and I don't mean to say that, but will I be appointed on?
Well, you're pointing on the first case, that whatever case that client gets, if it's still pending, you'll be pointed on that case as well.
Okay.
Yeah, that's the policy of Jefferson County.
Okay.
Okay. Now, let's see. So what you can do, just put your mic on. If you don't, do you have anywhere else to go?
Well, I have a mediation getting ready to start. That's why I had to appear by Zoom.
Okay. What time? How long you don't know how long that mediation is going to last.
I would hope that it wouldn't last long, but I can't promise. But
okay,
I can check in.
Yeah, you can do that. Just go ahead on and do your mediation, and you can check back in with us.
Yes, sir.
Okay. All right.
Thank
you. You're welcome. Let's see. Well, we have. Would you please call Rakima Harrison? Good morning. We're in session of cause number 328-486. Case of style of state of Texas versus Rakima Harrison. Ms. Harrison, is that your full name?
Yes,
How you doing, Ms. Harrison?
pretty good.
That's good. Ms. Harrison, you're here represented by your attorney, Mr. John Macy. Mr. Macy, how are you doing?
I'm fine, Your Honor, thank you.
That's good. Could you check and see if she has bond conditions? And Mr. Macy, Ms. Harrison's case is set on the court's announcement docket. You have an announcement you'd like to make in Ms. Harrison's case?
I do, Your Honor. We entered into, or she entered into an agreement with the state to do the batter's intervention program.
The BIP?
Yes,
Yes.
Okay. So we're gonna reset it for BIP. Okay. Give us a reset date. When is, has she started yet?
no, she just signed a document this morning.
Oh, she did?
Well,
With this,
She hasn't signed the contract yet.
yeah, she had signed.
It's tomorrow they're doing the contract signing, but this is too late to get into that.
So
one.
she'll
They'll have
probably
to-
get in December?
Yes, Judge.
Okay, let's reset it the second week in December. Okay, December 13th. The case is reset to December 13th, 2021, Ms. Harrison. Your attorney will be given a reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. And Mr. Mason, is this your last case?
Yes, Your Honor.
Okay, once you get your reset from my partner, you'll be free to go as well and you have a
Thank
blessed
you,
day.
Judge.
Okay. Jacob Wright. Oh, Jacob Wright. Okay, how you doing, Mr. Wright? I'm doing fine. This is cause number 329-824. Case of style of states, Texas versus Jacob Pierre Wright. Mr. Wright, you're represented by attorney Glenn Crocker. Mr. Crocker, how you doing?
Very well, Your Honor. Thank you very much.
That's good. Mr. Crocker, you have an announcement you'd like to make in Mr. Wright's case?
We do, Your Honor. Your Honor, we have received all the discovery and we have received an offer. I need an opportunity to review it all with my client. The works of the plants, our schedule don't necessarily mesh all that well, but we're gonna try to get together and get it all together so we can let the state know a definitive yes or no on the offer.
Okay, how much time you need?
In 30 days.
Okay,
December 1st.
was December 1st.
Yes, sir. That would be
Okay.
fine. Thank you.
Okay, the case is reset to December 1st. Mr. Crocker, you can get your reset. Once you get your reset from Attorney Crocker, Mr. Wright, you'll be free to go and you have a blessed day. And this is your last case?
Yes, sir.
Mr. Crocker, okay. Once you get your reset, you'll be free to go and you have a blessed day.
Thanks, Judge.
All right. Mr. Bailey, would you please go get Brandon Wales? This is cause number 330-078. The case is style of state of Texas versus Brandon Scott Wells. Is that your full name, Mr. Wells? How you doing, Mr. Wells? That's good. Mr. Wells, You're represented here by your attorney, Attorney Giles Cole. Attorney Cole is appearing via Zoom. Attorney Cole, how are you doing?
I'm doing great, Your Honor. How about yourself?
I'm doing fine. Thanks for asking. Attorney Cole, Mr. Wells' case is on the court's announcement. Doc, do you have an announcement you'd like to make in this case?
Your Honor, me and Mr. Wells have not been able to communicate.
Okay.
I think we need time to discuss this.
Okay.
If you don't mind, giving me a week, if possible, maybe the 14th, just to give us some time to discuss this offer.
Okay, you say 1 week?
Yes, sir. We don't need that much time.
Okay, give us a quick date. October the 13th?
Actually, could the 14th? I'll actually be out on the 13th. With the 14th would be great.
What's the 14th? Oh, our 14th is our jail run day.
Anytime after that is good for me, Your
We
Honor.
can put you on that Friday, which is the 15th, right? Yeah. we can
Friday
put you
will
on-
work.
Okay. So your case is going to be reset to October 15th. Mr. Wells, you can stand over there on the 4X, get your reset. Once you get your reset, you'll be free to go. You have a blessed day. Make sure you stay in contact with your attorney and your bondsman. All right. And Mr. Cole, your reset will be sent to you. I think this is your only case. And if it
Yes,
is,
sir.
you're free to go and you have a blessed day.
You do the same, Your Honor. Thank you.
You're welcome. Nobody's ready. Okay. Okay. Mr. Bailey, would you please call Nicholas Davies? Mr. Davis, would you please come forward? Mr. Lawrence? This is cause number 330126. Case is style of state of Texas versus Nicholas Caleb Davies. Is that your full name?
Yes, sir.
How you doing, Mr. Davis?
All right.
That's good. Mr. Davis, you're here with your attorney, Mr. Jack Lawrence. Mr. Lawrence, how are you doing?
Just fine, Your Honor. Let me get my other file.
Could you check and see if he got bond conditions? Nicholas Davies. Okay, thanks. Mr. Lawrence, you have an announcement you'd like to make in Mr. Davis' case?
Yes, Your Honor. We're asking the court to dismiss the case. We filed a motion to that effect. The complainant has filed an affidavit of non-prosecution, has given us, which we filed with the motion. And it is very plain if you read the affidavit that she does not want to testify. She does not want to be involved in this anymore. Really, I mean, that's what she tells the court.
Has the state filed a motion to dismiss the case?
The state has not, Your Honor, and the state has also communicated with Mr. Lawrence that in order for the state to consider an affidavit of non-prosecution in this case, that the complaining witness needs to take the options class, which is offered by our victim services.
Okay, so,
And I do have a second affidavit of non-prosecution, which is a little longer, which she signed, which
yeah, but that's not a basis to dismiss the case.
I can submit as well, it's.
And first of all,
sworn
Mr.
statement.
Lawrence, this case was not set for a hearing. This
It
case
is.
was set for announcement.
Well, if you'd like to set the motion for a hearing.
You can set the motion for a hearing. That's your motion. It's not the court's motion.
Mhm.
So you just get a setting from the court coordinator.
All right, that'd be fine.
Okay. Okay, so we're gonna set it for a pretrial hearing?
Yes, Your Honor, would you, a pretrial hearing, would that also, would you like for me to file pretrial motions in what case of?
You just said you had a motion to dismiss
Just a
that
motion,
was
okay.
filed, and I was trying to get a setting on the motion that you filed.
Okay, well, we can do it that way.
Yeah, I mean, I can't tell you how to practice. Okay. Okay, you can file whatever motions you think is appropriate in your case.
Yes, sir.
Okay. Let's give him a date on his pretrial motion.
Next week or on Monday?
No, we just, no, reset it, give us a standard reset.
Okay.
And yeah, I think we usually do our motions in the Fridays. I think we do them like on Fridays, right?
Pretrial, something like that.
Well, but I just want to do it maybe in the, not during the time that we have all other cases. Just like at a time certain, like maybe at a 1:30.
1:30, okay, to you.
I gotta pick my kids up to school at 1.
He picks up his kids at school at 1 o'clock. He has 3 children,
Hold on.
three small children.
Okay, okay. What day is December 3rd? Okay, so we're probably gonna set it at 11.
Mhm.
We should be,
Whatever time pleases. the court.
yeah, probably we should be hopefully finished whatever we doing on Fridays, off Friday. Let's do it at 11. Reset it for, and what was that date again? December 3rd. Okay, we're gonna reset it December 3rd, 11 o'clock for your pretrial motion. Once you get your reset, you'll be free to go. Mr. Davis, once you get your reset from your attorney, you'll be free to go and you have a blessed day. And Mr. Lawrence, I think this is your last case. Stand over there, sign the reset. Once you get your reset, you'll be free to go and you have a blessed day.
Thank you. Thank
Okay.
you, Your Honor.
Yeah, you get his reset from here. Yep. Did you get Mr. Gilthorpe's clients? Aguilar. I know Aguilar's. And you, and see if Amenadaris, see if Amenadaris is here.
Your notice of hearing out, that's just your reset for December 3rd, and I'm also gonna send you a notice of hearing. No, sir, it'll be something, that's just your reset.
But it'll be on the same date is what he's saying.
On the same.
Yeah. Jorge Aguilar, would you please come forward? This is cause number 330100, State of Texas versus Jorge Antonio Aguilar. Mr. Aguilar speaks Spanish?
Yes.
All right. Okay. Mr. Gilthorpe, would you please raise your right hand? Do you swear or affirm to interpret Spanish to English and English to Spanish to help you God?
Yes, sir.
You may put your hand up. Mr. Aguilar, how are you doing?
Very well.
Okay. Now, Mr. Aguilar, you're represented here by your attorney, Mr. Jared Gilthorpe. Mr. Gilthorpe, how are you doing?
Doing well, Judge.
Okay. Mr. Gilthorpe, you have an announcement you'd like to make in Mr. Aguilar's case?
Yes, Judge, we'd ask for more time. We have not received our video yet. We have our paper discovery, but we don't have our video.
Okay, you need time to get your video?
Yes,
Okay.
sir.
You want a standard reset?
Yes, Judge.
Could you?
December 1st.
Okay, it's gonna be reset December 1st of 2021. Mr. Aguilar, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Is it the-
Is his other client here?
He was gonna be getting on Zoom, I believe.
Oh, he was? Okay. Let's see, we have this, okay. Next four cases, cause number 322-826, cause number 323-924, cause number 325-164, and cause number 325-166. All four cases are styled the state of Texas versus Timothy Joseph Haynes. We have Mr. Haynes appearing via Zoom. Mr. Haynes, how are you doing? Okay, you have to take.
How are you
mic.
doing, Dave?
Okay, I'm
I'm
doing
sorry about
fine. Thanks for asking. Now, Mr. Haynes, you're represented by your attorney, Miss LaKayla Friday.
Yes, sir.
Miss Friday, how you doing?
I'm good, Judge. How are you?
I'm doing fine.
Judge, I'm well. How
thank-
are you? You can hear me okay?
Yes, I can hear you. I'm doing fine. Thanks for asking. Miss Friday, do you have an announcement you'd like to make in Mr. Hayes' cases?
Yes, Judge. I've had a chance to review all the discovery presented to me, and I got an offer from the state, and they have gave me, I'm waiting on it. Well, I gave them a counter offer. So can I just be set on the next announcement? I think that we can work it out. It depends on his offer back. So we're negotiating.
Okay. Which one? Yes. Okay, his cases will be set on December 1st of 2021. Ms. Friday, the reset will be sent to you. And Mr. Haynes, your attorney will be sent your reset. Stay in contact with your attorney and your bondsman. This will conclude your case, Mr. Haynes. Again, your case is reset to December 1st of 2021. You're free to go and you have a blessed day. And Ms. Friday, your reset will be sent to you. You're free to go and you have a blessed day as well.
You have a blessed day too,
Thank you,
Judge.
Judge.
All right, you're welcome. Uh-oh. Somebody ran into something. Did Mr. Kelly's client show up? Been
Your Honor, he
Cat
is,
Warren?
may I approach the bench, Your Honor?
Yes.
Should be appearing by Zoom. I've been in contact with him this morning
Okay.
and all week.
Okay, we'll wait. We'll wait
We've
for
got
him.
a resolution, Judge.
Okay, we'll wait for him.
Okay.
Okay. Okay, thank you. Could you call, Mr. Bailey, if you could call Justin Howard?
Good morning, Your Honor.
Oh, good morning.
Good morning. I wasn't talking to you either, Judge. So, I said I wasn't talking to you when I said, how are you ladies doing?
Oh, I
Because
was,
there's been several people on Zoom that seem to say, yes, ma'am.
oh,
He doesn't sound like, he doesn't have a high voice.
okay. We're in session and calls, hold on, no.
Justin
Okay,
Howard.
yeah, we're in session and calls number 330052, the state of Texas versus Justin Ronald.
Ronald. Your Honor,
It says, okay, it's like it says Roy Noel.
It does say
Yeah.
that, but it's pronounced wrong.
Ronald, okay, Justin Ronald Howard.
Yes, sir.
How you doing, Mr. Howard?
I'm good, and you?
I'm doing fine. Thanks for asking, Mr. Howard. You're here represented by your attorney, Attorney James Padgett. Attorney Padgett, how you doing?
Doing well, Your Honor. It's good seeing you.
That's nice seeing you as well. Mr. Padgett, you have an announcement you'd like to make in Mr. Howard's case?
Your Honor, I do. This is our first, well, actually, it's our second appearance. I finally received discovery on the case. I have all the discovery. I also have an offer from Miss Maxey now, which my client, I know he's going to be willing to accept. I just need some time to review the video.
Okay, how much time you need?
Just a regular reset, Your Honor. We'll be able to dispose of the case on the next setting.
Give us a reset date. What is it?
You said
December?
December 1st. If you don't mind, let me just take a peek while I'm here, just to
Okay.
make sure. That's a perfect day, Your Honor. I'll be in your court.
December.
Could I do the next Thursday? I have a 10:30 appointment.
Not a
that's out of
Thursday.
town.
Thursday's our.
I mean, Wednesday, I apologize. Could we do the very next Wednesday? Would that be acceptable to the court?
That might be the 8th. Was that the 8th?
I'm just looking at my schedule. And I
Okay.
know by 10:30, I'm gonna have to be in the room.
Okay, yeah, we're gonna reset your case till December 8th, 2021. You can get your sign and get your reset. And Mr. Howard, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Yes, sir, you too.
Okay, and I think, Mr. Paget, this is the only
It
case you
is my
have?
only case.
Okay.
May I be excused?
Yes, you may be excused. You have a blessed day as well.
Take your time. You keep me from my office.
Is Maisha Carter? Did Maisha Carter appear? Okay. Mr. Carter, this is cause number 330154, State of Texas versus Maisha Carter. How you doing, Ms. Carter? I'm doing fine. Thanks for asking, Ms. Carter. You're here represented by your attorney, Attorney Marvin Provo. Attorney Provo, how are you doing? That's good. Okay. Ms. Provo, you have an announcement you'd like to make in Ms. Carter's case?
Yes, Your Honor, we would like to see, reset to another announcement that.
Okay. Okay, discovery. Okay, and the bailiff is just informed me that Ms. Carter has a warrant out. Do we know what the warrant is for? Is it a new case? Two new cases were filed? You have two new cases that were filed. Hold on, wait up. It's one case, false report. A false report to a public servant? That was just recently filed. And so, yeah, you would have to be taken into custody. And then we'll set your bond. Just have a seat in the jury box. Okay, and what we're gonna do, I'll just have a bond here, and once we just have a seat in the jury box. And y'all just make sure you social distance. Okay, just have a seat. I'm gonna have need to get some information. Yes.
Your Honor, I'm
Indicate
here on
for-
Vice Secretary Kate Swarm.
Okay,
Judge, I've been in contact with my client during the entire pendency of this case. We haven't missed an appearance. I've spoken with them all week via Zoom and phone. I think this is a connection issue, Judge. He's out of the country. He's been out of the country since COVID began, which is somewhat prevented him from getting here. So
yeah, I mean, he could appear by phone or Zoom.
that's what I'm saying, Your Honor. He's out of the country. I think it's created a connection. He's in India. And we have a resolution, so I'm just asking the court to.
Okay, well, you said it's connection is for me. I don't know that to be true. I mean, I know he's out of the country.
I'm offering as an officer of the court that he's in India.
I understand. I've accepted that. What I'm saying is the connection issue. Do we have any
Well, I know
way
that I've
to
spoken
know
with-
that he has a connection issue?
I know that I can't get a text message to go through to him, and I've spoken with him on.
Okay. Well, what we'll
occasions
do,
than
I
can
mean,
recall.
we'll normally we don't do our bond forfeitures like 4 p.m. We'll just give you time to continue to try to contact him. I mean, you got 6 hours.
Well, my other issue, Judge, is it's midnight where he is, so.
Oh, well,
If Your Honor can allow for just a little bit of grace, knowing that this case is, we've got a resolution.
well, I
It's gonna be
mean,
resolved.
yeah, but I don't, I mean, at this point, I mean, he has the court has given him 3 ways to appear. And 2 of them he could do either by telephone. I mean, it's midnight over there. I don't know if he's up or not up. I don't know what the deal is. But he has not made an appearance either by telephone or Zoom. And the court is giving him, at least giving you 6 hours to see if you can get him to appear by either telephone or Zoom, so you're gonna have to continue to see, try to make contact with him. Yeah. Okay,
Thank you.
so you're excused. Mr. LeBlanc. Mr. Bailiff, would you please get Laquela Brooks? Oh, that's right. Okay. Did you sign the discovery certification on Brooks? Oh, you still in it? We're in session in cause number 329-870. The case is style of State of Texas versus Aquila Brooks. Ms. Brooks, is that your full name?
Yes.
How you doing, Ms. Brooks?
How you doing?
I'm doing fine. Ms. Brooks, would you please raise your right hand? Ms. Brooks, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Brooks, you may put your hand down. Ms. Brooks, you're here represented by your attorney, Mr. Todd LeBlanc. Mr. LeBlanc, how are you doing?
Good, Judge. Thank you.
I'm doing fine. Ms. Brooks, I have before me an information that alleges that on or about March 2nd of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Ms. Brooks, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Brooks, how did you plead? Guilty, not guilty, or no contest? Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes,
Okay. Now, Mr. LeBlanc, do you waive a record in this Ms. Brooks case?
We do.
Now, Ms. Brooks, I also have before me a document that is titled the misdemeanor plea admonishment. On page 1 of this document, do you recognize this document? And on page 2 of the same document, there are a set of initials on the line, LB on the line next to the box that's checked, that's guilty. Are these your initials?
Yes.
On the next page of the same document, there's a signature at the top above the line that's titled Defendant. Is that your signature? And on the next document, that's titled Trial Court Certification, the Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled Defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes,
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
yes.
I also have before me a document that is titled the Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Ms. Brooks, prior to signing and initialing these documents that I just mentioned, did your attorney go over these documents with you? Yes. And did you read these documents? And did you understand that what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Ms. Brooks, well, state, I have before me State's Exhibit number 1. State, you like to offer State's 1?
Yes, Your Honor.
We have no objection.
No objection. State's Exhibit number 1 will be admitted. Mr. LeBlanc, you have advised that counsel, Ms. Brooks, is there any evidence that she is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
Ms. Brooks, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Brooks, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
15 days county jail.
Okay. Ms. Brooks, the state is offering that you serve 15 days in the Jefferson County Jail. You'll also be required to pay court costs of $452. Ms. Brooks, will you be able to pay the $452 prior to you being released?
I don't have the money right now, sir.
Okay, could we get a affidavit indigency?
And
See
Your
if she
Honor, I'm
has one on
sorry,
file.
and check-in would be on Friday, this Friday, October the 8th at 6 p.m. if that's okay.
It'll start October the 8th
Yes, Your Honor.
at about 6 p.m.
And I believe she has 13 days credit, which I know we can't put it on there, so I told them that we might just have to check in and check out.
Okay, just hold on a minute. Thank you. Mr. Blunt, could you show this to your client? Ms. Brooks, your attorney is handing you a document that is titled Affidavit of Indigence. And on the second page of that document, there's a signature. Is that your signature? Did you, prior to signing that document, did you read and understand everything in that document? And is everything in that document still true and correct today? Okay, based on the information that has been provided in your affidavit of indigency, the court has previously found that you met the eligibility requirements for the appointment of court-appointed attorney. That is, the court found that you were indigent. The court is also making that finding today that you are still indigent. And so therefore, the court costs in this case of $452 will be waived pursuant to Article 4215 of the Texas Code of Criminal Procedure. Okay. So the court costs going to be waived. So therefore, your punishment is 15 days in Jefferson County Jail. You'll be given credit for any time that you're entitled to get by law. And the court costs of $452 will be waived pursuant to Article 4215 of Texas Code of Criminal Procedure because the court has found that you're indigent. Okay. Okay,
And Judge, I'll make sure you're okay with her turning herself in Friday.
yes, that's what the agreement was. She'll turn herself in on October the 8th, 2021 at or about 6 p.m. All right, stand over here on the X, and we're gonna follow the directions of our court clerk.
I just received a message, Mr. Bruce Smith is,
Okay,
assistant here in both their
right,
classes.
okay.
She just wanted me to let you know that she's here. So
Yeah, I
now
saw, she's sitting right
she wanted to know if they can go ahead and recess because he might be in a hearing for a while.
there. Now we don't give Reese, well, what hearing is he in? Is he, what,
He's in the
in 279?
It was supposed to have been a default temporary hearing, but the other party showed up and from my understanding, the word I'm getting from
Okay, okay. Okay, thanks.
And Judge, I'm not trying to jump in here. I can wait if the court would prefer, but I am ready on my client when the court gets a chance.
Okay, okay. Mr. Okay, Mr. Gertz, you're signing your client up?
Yes, Judge.
Okay.
It's a novel thing for me, right?
Judge, tell Mr. Gertz if he needs help with the paperwork, he can reach out to me.
Thanks, Charles.
Okay, he heard you. Okay, would you please get Kayla Newton?
These are copies that you need to bring. At least one of them, make sure you check in. They won't let you in.
Okay, we're in session and cause number 329714. Case is style of State of Texas versus Kalen D. Newton. Mr. Newton, is that your full name? How you doing, Mr. Newton? That's good, Mr. Newton. You're represented by your attorney, Mr. Charles McIntosh, who is appearing via Zoom. Mr. McIntosh, how are you doing?
Doing well, Judge. Thank you.
Mr. McIntosh, do you have an announcement you'd like to make in Mr. Newton's case?
Yes, Judge. I was able to speak with the district attorney's office yesterday. There was a little bit of a snafu, I think, on somewhere, but I was able to get discovery yesterday. However, I have not had a chance to look at it nor show it to my client. So we just asked for a standard reset.
Okay. Okay, the case is going to be reset to December 1st of 2021. Mr. McIntosh, your reset will be sent to you in the mail. Well, it'll be sent to you. And is this your only case, Mr. McIntosh?
Yes, Judge, it is.
Okay, so you're excused, you're free to go, and you have a blessed day. And Mr. Newton, you can stand on the far X, you can get your reset from our court coordinator. Once you get your reset, you'll be free to go as well, and you have a blessed day.
All right.
Thank you, Judge. And Mr. Newton, I'll be in touch with you.
All right.
Yeah,
Yeah.
that's David Grove. That's the oh. Okay, we're in session in cause number 328192. The case is style of State of Texas versus Juan Gabriel Pagoda Bastillo. cause number 328-192. Mr. Bastillo, is your full name Juan Gabriel Pagoda Bastillo? How are you doing, Mr. Bastillo? You doing good? Okay, Mr. Bastillo, would you please raise your right hand? Mr. Bastillo, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. Mr. Bastillo, you're here represented by your attorney, Mr. David Grove. Mr. Grove, how are you doing?
Good, Judge. Thank you.
Mr. Grove, do you waive a record in Mr. Bastillo's case?
Yes, Your Honor.
Mr. Bastillo, I have before me an information that's Kelly's client. I have before me an information that alleges that on or about October 28 of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive from justice. Mr. Bastillo, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Bastillo, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you're actually guilty?
Yes.
Mr. Bastillo, I also have before me a document that is titled the misdemeanor plea admonishments. And on page 1 of this document, do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials, JP, on the line next to a box that's checked guilty. Are these your initials?
Yes, sir.
And on the 3rd page of the same document, there's a signature above the line that's titled Defendant.
Yes, sir.
Or is this your signature?
Yes,
Is, okay. On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, is this your signature
Yes, sir.
on this document that's titled Trial Court Certification, Defendant's Right of Appeal? Now, there are 2 boxes that's checked at the top of this document. The first box check states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal. Do you understand that?
Yes, sir.
Mr. Bastillo, I also have another document here. This document is titled the Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled Defendant?
Yes, sir.
Oh, now, Mr. Bastillo, prior to signing and initialing those documents that I've just shown you, did your attorney go over these documents with you?
Yes, sir.
Did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer States 1?
Yes, Your Honor.
Any objections?
No objection, Your Honor.
Okay, no objection. State's Exhibit number 1 will be admitted. And Mr. Grove, you advised and counseled Mr. Bastillo. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
Mr. Bastillo, your attorney, Mr. Grove, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Okay, Mr. Bastillo, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers was freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
1 year deferred adjudication, $500 fine, and 40
Okay.
hours community service.
40 hours community service?
Yes, Your Honor.
Okay. Mr. Bastillo, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $352. You'll also be required to pay $60 each month in probation fee, $15 each month in your analysis fee, and reimburse Jefferson County the court-appointed attorney's fees of $250. Your total monthly installments will be $175 per month. Mr. Bastillo, will you be able to pay the $175 each month? And Mr. Bastillo, you'll also be required to perform 40 hours of community service and adhere to the other standard terms and conditions of this probation. Do you understand that? Okay, Mr. Bastillo, do you understand the state's offer? Do you think that the state's offer is fair and just? Do you accept the state's offer? Okay, Mr. Bastillo, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Bastillo, if you successfully complete the probationary period, this case will be dismissed. It will not appear on your record as conviction, and you may qualify for a non-disclosure. You can talk to your attorney, Mr. Grove, about the non-disclosure. He's quite competent on those matters. Mr. Bastillo, stand on the X next to your attorney. You're going to follow the directions of our court clerk. And once you finish following her directions, you'll be free to go, and you have a blessed day. Thank you. Okay, Mr. Kelly.
Yes, Your Honor.
Okay, Mr. Kelly, your client is on Zoom.
Yes, Your Honor.
Is that Vizak Venkateswaran?
Isaac, yes, Judge.
Okay. How you doing, Mr. Venkateswaran?
Well, Judge.
That's good. Okay, this is cause number 325-818. Mr. Kelly, again, how are you doing?
I'm great, Judge. Thank you.
And what is your announcement?
We've reached a resolution, Judge. If you'd set us off onto a plea docket to give us some time to get it completed.
How much time do you need?
45 days, Judge.
Okay. What about November 29th?
That'll be great, Your Honor.
Okay, case is reset to November 29th of 2021. Mr. Venkateswaran, stay in contact with your attorney, Mr. Kelly and Mr. Venkateswaran. Your case has been reset until November 29th of 2021. And Mr. Kelly, is that going to be a plea on that date, or what is it?
Judge, we expect to handle this in a justice court before even having to return to you, Your Honor.
Oh, so it'd be a JP reduction?
That's correct, Your Honor.
Okay, thank you. Okay. Mr. Venkateswaran, you're free to go, and you have a blessed day. And Mr. Kelly, you're excused. Your reset will be sent to you. You're free to go as well, and you have a blessed day.
You as well, Your Honor. Thank you.
All right.
Show you where it is.
Alvarado. Oh, it just popped up? Okay.
On Stephen Robertson.
Where? Robertson? Okay, yeah. Okay, this is cause number 325-472. Case is style of State of Texas versus Stephen Earl Robertson.
Judge, this is going to be a forfeiture for dismissal. So we have the motion to forfeit the weapon in this case.
Oh, so you already signed the dismissal?
I'm signing it right now.
Oh, okay. This is cause number 325-472. Case is filed the state of Texas versus Stephen Earl Robinson. Mr. Robertson, is that your full name?
Yes, Your Honor.
Okay. Mr. Robertson, how are you doing?
Very well, yourself?
I'm doing fine. Mr. Robertson, would you please raise your right hand? Mr. Robertson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your
You
Honor.
may put your hand down. And Mr. Robertson, you're here represented by your attorney, Rick Oliver. Mr. Oliver, how are you doing?
I'm doing well, Judge. How are you?
I'm doing fine. Mr. Oliver, do you waive a record?
We do, Your Honor.
Okay. Now, Mr. Robertson, I have before me a motion to forfeit the weapon in cause number 325-472. Do you recognize this motion?
Yes, Your Honor.
And Mr. Robertson, is this your signature above the line that's titled defendant?
Yes.
Now, Mr. Robertson, prior to signing this document, did your attorney go over this document with you?
Yes.
And did you read and understand everything in this document?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes, Your Honor.
Okay. Now, Mr. Robinson, I will grant this motion that has been filed to forfeit the weapon in cause number 325-472. And based on the plea bargain agreement that you have entered into with the state has informed me that this case will be dismissed. And I'll be signing the dismissal in a few minutes. Just sign the dismissal, it'll be printing off in a few seconds. It's not printing off? Oh, there it is. Okay, Mr. Robinson, I just signed a dismissal. You can get a copy of that dismissal from our court coordinator. Once you get a copy of your dismissal, you'll be free to go and you have a blessed day. And Mr. Oliver, you have a blessed day as well.
Thank you, Judge. You too.
Thank you.
I have another dismissal that I'm signing to Mondragon. That was on the docket. And we're in session in cause number 329-810. Case is style of State of Texas versus Jorge Rene Alvarado. Your full name is Jorge Rene Alvarado?
Yes, Your Honor.
Mr. Alvarado, would you please raise your right hand? Mr. Alvarado, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Judge.
You may put your hand down. How are you doing, Mr. Alvarado?
I'm doing well. How are you?
I'm doing fine. Thanks for asking. Mr. Alvarado, you're here represented by your attorney, Attorney Ryan Gertz. Attorney Gertz, how you doing?
Great, Judge. Thank you.
That's good. Attorney Gertz, Attorney Gertz, do you waive a record in Mr. Alvarado's case?
Yes, Judge.
Okay. Mr. Alvarado, I have before me an information that is, that alleges that on or about March 30th of 2021, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Alvarado, do you understand what you've been charged with?
Yes, Your Honor.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you are guilty?
Yes, Your Honor.
Mr. Alvarado, I have before me a document that is titled the misdemeanor plea admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there are a set of initials, JA on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, Your Honor.
On the third page of the same document, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, Your Honor.
And on the next document, which is the trial court certification of defendant's right of appeal, do you recognize this document?
Yes, Your Honor.
And is that your signature above the line that's titled Defendant?
Yes, Your Honor.
There are two boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, Your Honor.
The second box states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that?
Yes, Your Honor.
Mr. Alvarado, I also have before me a document that is titled the Discovery Certification. Mr. Alvarado, do you recognize this document? Is this your signature above the line that's titled Defendant? Now, Mr. Alvarado, prior to signing and initialing these documents that I have just mentioned, did your attorney go over these documents with you?
Yes, Judge.
And did you read and understand everything in these documents?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Judge.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
Any objections?
None, Judge.
No objections. State's Exhibits Number 1 will be admitted. Mr. Gertz, you've advised and counseled Mr. Alvarado. Is there any evidence that he is currently mentally incompetent to stand trial?
None, Judge.
Mr. Alvarado, your attorney, Mr. Gertz, has advised and counseled you. Are you satisfied with his representation?
Yes, Judge.
Has he provided full, effective, and competent legal representation?
Yes, Judge.
Okay, Mr. Alvarado, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 180 days probated over 1 year, a $750 fine, 60 hours of community service, DWI education, drug and alcohol assessment, and interlock device.
Okay. Mr. Alvarado, the state is offering that you serve 180 days in jail. However, you will not have to serve any time in jail in this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $750 plus court costs. The total fine and court cost is $1,217. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, you will be required to pay Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments that you'll have to pay is $190 per month. Will you be able to pay the $190?
Yes, Your Honor.
Mr. Alvarado, you will also be required to perform 60 hours of community service, attend a DWI education class, and have a drug and alcohol assessment, and install the DWI interlock device on any vehicle that you own or operate. And you'll also be required to adhere to the other standard terms and conditions of probation. Mr. Alvarado, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case will be fair and just?
Yes, yes, Judge.
And do you accept the state's offer?
Yes, Judge.
Okay. Mr. Alvarado, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Alvarado, please stand on the X next to your attorney. Follow the directions of our court clerk. Once you finish following her directions, you'll be free to go and you have a blessed day. Okay, this is cause number 329402, case of style of state of Texas versus Chase Morgan Kimball. Is that your full name?
Yes, sir.
How you doing, Mr. Kimball?
Oh, pretty good.
That's good. Mr. Kimball, I see the last time you was here, your case was reset to give you opportunity or time to hire an attorney. Have you hired that attorney?
No, sir. I'll just try to go for a court appointment because I can't find a job anywhere.
Okay, just have a seat. We're gonna give you a clipboard with an affidavit of indigence that you need to fill out. Okay, just have a seat in the gallery. Anthony McGill. This is cause number 328816, case of solid state of Texas versus Anthony McGill. Mr. McGill, how you doing?
I'm doing fine.
That's good. Mr. McGill, the last time you was here, Your case was reset to give you opportunity or time to hire an attorney. Have you hired your attorney?
No, sir, I was gonna, mind if I speak? Yes, sir, I was gonna ask you for like another week or two.
Okay, what we're gonna do, you just need some more time to hire your lawyer?
Yes, sir.
Okay, we're gonna reset you a month.
Okay.
Okay.
And I wanna let you know that I got in that class you was telling me about, Proctor Street. Industrial class.
Oh, you talking about CICE?
Yes, sir, yes, sir.
Okay, well, that's good. That's good. That's good. That's part of our CSI program.
Yes, sir.
Okay, well, that's good. Okay, now, Mr. McGill, you're gonna stand on the X, the 4X in front of our court coordinator. She's gonna reset your case to give you a time to hire your attorney of your choosing. All right? You're welcome. December 1st? Okay. Case is gonna be reset December 1st. Mr. Bailey? Oh, yeah, okay. Miss Provo? And Miss Carter, would you come forward? Somebody is, Mr. Bailey? There was a lady in the door. Okay. I'll look at the facts. Let's see. Now, Miss Carter. Would you please raise your right hand? Ms. Carter, do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Now, Ms. Carter, I need to get some information from you. Let's see, Ms. Carter. You currently live in Beaumont?
Yes.
And you employed with Synergy in Beaumont?
Yes, with Synergy and Focus. Synergy and Focus.
And Focus?
Focus call center.
Focus.
Mhm.
Okay. So you employed in Beaumont, okay. Have you been living here all your life?
Mhm.
Do you have, are these the only cases that she's ever here? Okay. Now, Miss Maisha, do you have like any convictions outside of Jefferson County? None? Okay, just what we have here, okay. And apparently you don't have any convictions at all because these cases are just pending. Is that correct? Okay. You appointed on these cases?
I was appointed on the first one.
Oh, wait, you'll be appointed on the second one too, because it's they the same kind. Okay. Does she have a affidavit of indigence on file?
She had a cash phone as well.
So she put up a cash bond? Okay. Okay, that's fine. So she has been in previous bond forfeitures. This is a new, did she have a bond forfeiture in the case before, in this case?
Not in, no.
Never one, okay. What is outstanding bond in the case that she currently has? What's the current bond? Oh, it's a cash bond that she put up.
She put a cash bond of 500.
So the bond is 500.
This, on this case.
Right.
Yeah.
Do you need to talk to her?
No, you go ahead.
No, I was just reading the facts of the case. If y'all need some time to talk, I'll give y'all time to talk.
Okay.
Okay, you can have a seat. Okay. We're in session of cause number 330038, case of Solid State of Texas versus Cariana Savoy. Ms. Savoy, is that your full name?
Yes, sir.
How you doing, Ms. Savoy? You doing good? Okay, Ms. Savoy, last time you were here, your case was reset to give you an opportunity to hire an attorney. Have you hired that attorney?
No, sir.
Do you need more, do you still want to hire an attorney?
No, sir.
Okay, now you have three options. One option is, and the options that I read to you the first time you was here, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Or number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, you said that you do not want to hire an attorney, is that correct?
Yes, sir.
So your other choices is if you want to apply for a court-appointed attorney, then you will sign, you'll put your initials on the third line to the left. If you've already been appointed to the court-appointed attorney, then you put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, you'll put your initials on the fifth line to the left. Now, you have that document in front of you that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you have that? Okay, you can just take a seat and fill that out. Also, we're gonna need Mr. Oh, that's hers. Oh, she already filled out one.
She wasn't.
Oh, yeah, oh, okay, you had already did this. And then, yeah, you weren't eligible, because you only had, you had $1,100 and almost $1,200 a month left over. Yeah, now, Mr. Savoy, you recognize this document?
Yes, sir.
And is this your signature on this document?
Yes, sir.
Now, Mr. Boyd, is everything in this document still true and correct? Or is it, or some changes have been made?
No, that's right.
Okay, so you're saying you make about $1,192 a money and your bill is only $79 a month?
Yes, sir.
So which means you have $1,120 left over each month?
Yes, sir.
Okay, so, I mean, based on that, you have enough money to hire an attorney. So, I mean, you don't qualify for a court-appointed attorney based on what I'm looking at, the amount of money that you have left over. Okay, and I think we told you that the last time, right? And so we gave you an opportunity to hire an attorney. Have you talked to any attorneys?
I don't want to hire you.
Huh?
I don't want to hire you.
Oh, so you don't want to hire none? So you want to represent yourself? Okay. Now, Mr. Boyd, if that's your choice, you will have to sign, you can put your initials on the fifth line to the left on that document. And there's a second document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding a Trial. They say, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised the 6th day of October of 2021 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed me free of charge, understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel. I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that's your choice, then you will sign at the bottom where it says defendant and put today's date. Okay, now, Mr. Boyd, you'll have an opportunity to talk to one of the prosecutors. Just have a seat in the gallery. Okay, let me, hold on a minute. Just hold on a minute. And we're back on the record, and Kimball, I have before me an affidavit of indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, Mr. Kimball, did you fill out this, what they call the unsworn declaration by defendant?
Yeah.
Is that correct? And is
What's the
every,
difference with, I didn't see the one at the top, like where you highlighted, what's the difference?
one of them you're taking oath? Yeah. This is sufficient?
Yeah, he signs the bottom.
This is
Okay, because I didn't see that mark at the top, I think that's what I'm gonna say.
Okay, now is everything true and correct in this document?
Yes, sir.
To the best of your knowledge?
Yes, sir.
I also have before me judge's explanation of defendant's right of appeal. Well, judge's explanation of defendant's rights to, and it's without an attorney.
Yes, sir.
Without an attorney. Now, Mr. Kimball, you recognize this document?
Yes, sir.
Is that your signature on the bottom of this document?
Yes, sir.
And are these your initials on that stating you want to apply for court-appointed attorney?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Kimball, I've read and I've looked at both of these documents, on the affidavit of indigence. Apparently you don't have any income, no bills, however you do receive benefits, so you are automatic qualified. And based on that, based on the information that you provided here, you qualify for a court-appointed attorney. Mr. Kimball, your attorney is going to be Attorney Mark Faggett. Please stand on the X in front of our court coordinator. That was for the other lady. Okay.
You actually do have to sign this part. You're just not taking the oath right here.
There you go. Okay, let's see.
The only other ones we have is Saul and Stevenson.
You could have them.
She didn't show up, but Saul hadn't heard from his attorney.
Okay, just have him come in. Oh. Okay, you have an attorney. I can't, speak to you. You have to speak through your attorney. Okay, let me, let's see, this is cause number, okay, this is cause number 3294418. Case of style of the state of Texas versus Jose Armendariz. We have Mr. Armendariz appearing via Zoom. Mr. Armendariz, can you hear me? It says it's still connecting to audio. Mr. Armendariz is appearing, well, is represented by attorney Jared Gilthorpe. Mr. Gilthorpe, how are you doing?
Doing well, Judge.
Okay, I think, no, he must have. Mr. Armendariz, can you hear me?
Señor Armendariz, ¿le puede escuchar a un juez?
Well, yeah,
He's present, Judge. I don't know
Yes.
if he, I can make the announcement. I don't know if he really
Okay.
did.
Okay, what is your announcement? Oh, Mr. Gilthorpe is having, his thing is stuck. Mr. Gilthorpe's, yeah, you were stuck. Okay, what's your announcement?
My announcement, Judge, we're still waiting on our videos on that case. And so we'd ask for a reset just to get time for the DA's office to get us our videos.
Okay, the case will be reset. Give me could you give us a reset date for Armendariz? They need some time to get the video.
December 1st.
Okay, case is gonna be reset to December 1st of 2021. Mr. Gilthar, your reset will be sent to you, and you can let your client know that his case has been reset till December 1st of 2021, and you're free to go.
Thank you, Judge.
Okay, you're welcome. Yeah, I removed him, so.
Okay.
Mr. Rojas. Okay, so. Adam Soul, would you please come forward? Okay, we're in session in cause number 3287730, case of style of state of Texas versus Adam Soul. How you doing, Mr. Soul? I'm doing fine. Thanks for asking, Mr. Soul. You're represented by your attorney, Mr. Charles Rojas, who is appearing via Zoom. Mr. Rojas, how are you doing?
I'm doing well, Your Honor. How are you?
I'm doing fine. Mr. Rojas, you have an announcement you'd like to make in Mr. Soul's case?
Mr. Soul's case, he also has a felony case that was set this morning. My understanding is that he's already been over to Judge Stevens and has a reset. So I'd ask that this get reset along with that felony case.
Do you know your reset date?
Yes, it'd be the 15th of December.
Okay, your case, we're gonna reset your case with your felony case. Mr. Soul, you're gonna stand on the X in front of our, 4X in front of our court coordinator, so you can get your case reset. Once you get your case reset, you'll be free to go and you have a blessed day.
Thank you, sir.
And Mr. Rojas, your reset will be sent to you. You're excused and you have a blessed day.
Thank you, Judge.
Thank you. Okay. Ms. Leah Daigle. Okay, Ms. Daigle, I just need to get, Ms. Daigle, would you please raise your right hand? Ms. Daigle, do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? I just need to get just some background information on you. No information, I don't need any information regarding the case. I just need some information so I can get to enough information to set a bond in your case. Now, Ms.
Can I say one?
Well, Ms. Daigle, let me tell you this here. Ms. Daigle, you have a right to remain silent. Anything that you say can and will be used against you in the court of law. You have a right to have an attorney. In fact, you do have an attorney. And so, of the abundance of caution, the court will, before you say anything, the court would allow you to talk to your attorney first to get it cleared from your attorney. I'm not going to.
Okay, this is nothing that anybody in the world can hear.
I'm not, that's, okay, well, let me do this here. I'm not gonna allow you to say anything without getting your attorney, because anything that you say can be incriminating, and it can be used against you in a court of law, okay? So the information that I need to get right now is, Ms. Daigle, to set this bond. Do you currently live in Port Arthur? You still live in Port Arthur, Texas?
No, sir.
Okay. Do you live in Jefferson County?
That would be about, the address that I have right now is a mailing address.
Okay, but my question is, where do you reside? What county?
Right now, I guess Jefferson County.
Okay, that's what I need. Okay. Okay. And let's see. Now, are you, I see here, are you employed or are you not employed? Employed? Good.
as much as I can be. Yes, sir, always. When there's jobs to be found.
Could you check, to see if there was any previous bond forfeitures? Okay, no. Now, Ms. Daigle, let me, could you hand this to Ms. Daigle? That's an affidavit of indigence. Would you please review that document, Okay, yes, that's what you filled out the last time you was there, here. And is everything still the same in that document? Any changes?
It's about the same.
Same, okay.
Yes, sir.
That's what I need to know. Got enough financial information on you. Let's see. So you live in Jefferson County. These are only two cases that she has in the county?
So,
No,
Yes, sir, I printed you that.
okay, that's what that's what I'm saying on here. Nothing else, okay. So she has no prior conviction, it's just all pending.
and I've tried to take care of both of that. Yes, sir. Matter of fact,
Ms. Daigle, again,
don't say anything.
you have a right against self-incrimination. Anything that you say can and will be used against you in the court of the law. Now, today, only thing I'm trying to do right now is set a bond. At this
Don't
time,
make it too much because I don't
at,
have a lot of
well,
money with me.
okay, we are, and looking at the, trying to get the information so that the court can set a reasonable bond. Okay, that's why the questions that I'm asking you, I'm looking at your documents, looking at your affidavit of indigence that you filled out. I have your financial information. I have your criminal history. I have the fact that, you know, you live in this county, so you have ties to this community. You do not have any previous bond forfeitures. And what is what is her outstanding bond? In the current case, I think she is a cash bond. I see it. Hold on, I think I see a cash. Oh, 750. Okay, cash. Okay, I see she had a cash bond of 7. Okay, so that's your outstanding bond. All this information that that I have before me. Of course, I also had a facts of the case as well. That's going to be taken into consideration as well. Now, one of the things, and I think I mentioned this to your attorney, that we've gone to set bond conditions in this case. And the reason why we have, well, bond conditions, you have two outstanding bond forfeitures. I mean, two outstanding bonds. Excuse me. So you have,
About today, I just found out about that today when you said it.
I understand.
That's when it came up.
Okay, now, Ms. Daigle, I think that's what we had mentioned. It was brought to the court's attention. And I think what happened was, one case was in November of 20, the other case was October of 20, but for some reason, the October of 20 case was filed first. And then just recently, the November 20 case was filed first, and then the October 20 case was just filed. Why? I have no idea, but understand, but just be patient. We're just trying to set a fine, we're just trying to set a bond in your case. Okay? So just, do you need to take a seat or anything? Okay.
That's what I just asked.
Yeah,
That's what
okay,
I guess.
just,
But other than
okay,
that,
okay. Just
I'd like
follow
to
the
finish
bill.
talking.
Okay,
So,
just follow the bill.
please, thank you.
Okay. Okay. Now, okay, now, Ms. Daigle, I looked at obviously you have community and I guess family ties and employment tied to Jefferson County. So you have contacts of Jefferson County. I looked at the facts of the case and also looked at your criminal history. And the court is assessing your ability to pay a bond. The court also looked at your affidavit of indigence that you previously signed on on August the 17th of 2021. And the court is going to take into consideration this information, as well as you have not had any previous bond forfeiture. You do have an outstanding bond of $750. The court is going to order that as a condition of bond, that you get an interlock device. In essence, any vehicle that you own or operate, let me do this. Could we make a copy of the city's bond conditions? These are just bond conditions. We're gonna give it to you. Just hold on a minute. Just hold on a minute. Oh, tell him, I need to put both of those case numbers on there. Just tell him stop. I need to put both of those case numbers on there. I just had one case number on it. I need to put both of them on it. Thank you.
Too late, Judge.
Oh, he's fast, huh? We're gonna have to copy the first page. Let me see this. 3, 2, 8. You can copy the first page. What was it?
She just got paid and it'll be 2 weeks before she gets paid again.
Oh, okay. This must be okay. Give her the copy. Show you out that first page. Now, Ms. Daigle, these are your bond conditions. And your bond conditions, I'll go over these bond conditions with you. It says standard bond conditions in County Court at Law Number 2. Now, following arrest and or accusation in County Court at Law Number 2, Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or orders subject to the following additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Okay, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. And condition, do you understand that condition?
Yes, sir.
Okay. And condition number 3 doesn't apply because there's no victim actually in this case, other than the state of Texas. Now, which is a complaining witness. The condition number 4 states that a defendant who has been arrested or accused of any offense listed under section 49.04 through 4906, that's the DWI statutes. Okay. Of the Texas Penal Code shall not operate any vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day. And that's going to be after arrest, which is today. So you'll have 10 days in which to get the interlock device. And the amount is being, the amount of the interlock, I don't know what it is, but it is also being taken into consideration with regards to the setting of this bond, okay? And so also, let's see. Now, I do know that you have a $750 cash bond that you posted with Hardin County, I think.
Correct, just, I didn't.
I know, I'm just saying, but that bond is still good, so that's in the other case. You had posted a $750 cash bond. Now, in this case, state, you have any recommendations as to a setting of a bond in this case?
The state would defer to whatever.
Okay.
the court.
Okay. Okay, so what the court is going to do, the court is going to set in, take into consideration the facts of the case. That's one of the things, even though, and no, I say even though, but there is some aggravating factors in this case, and that was a major accident according to the PC. And also, there, on the other side, it shows that you are employed. However, you're a part-time employee with about 20 hours per week. And based on your affidavit of indigence, which you say is still the same, and I'm not going to state what that amount is in open court, but the court has viewed it, and the court has taken that into consideration. Also, this was the first case that should have been filed way back. I can say way back when, or last year, should have, right, they should have filed it last year, but some reason they got 2 years to file it, but for some reason this one got filed after the second case that was filed first. Now, what we're going to do, as I said, you have to get an interlock. This bond,
How long do I have to keep that? How long do I have to keep that interlock type?
as long as the
something?
case is pending. During
As long as this case is-
during the pendency,
This case or
both
the
during
one
the.
that I tried, I mean. I'm
No,
trying to
it's,
take
it's,
care of
it's,
both.
as long as you're out on bond, and that's a condition of your bond. And so when the bond ends, the conditions of your bond end. And your bond normally does, well, your bond doesn't end until your case or cases are completed. Okay?
Set of paperwork I have from that.
Okay, so the duration will be, this is a condition of your bond. Okay. So what we're going to do is, and this is you could make a cash bond or you could do a surety bond. A surety bond is where you get with a bondsman. Okay. And so normally, so this bond, I'm gonna just set it at the same amount that the previous bond was set at, which is $750. And now you can talk to the jail personnel, you could talk, let you talk to the bondsman.
I tried to get a bondsman to take it and they said they wouldn't.
Or Well,
I couldn't get them, so I ended up
Well, that-
staying and then,
but, you know,
had more, and then found that job and then got more money. And that's how I was able to buy myself out.
okay, normally these bonds would be a lot higher, but the court is taking into consideration the fact that you are, your indigency status and plus the fact that you will be required to get an interlock. So that was taken into consideration. Other than that, your bond would have been, I'd say substantially higher than what it is right now. So, but the court is requiring the interlock because as a condition of bond, the court is concerned with the safety of the community. And so we think that having an interlock, actually, if you have an interlock, you can't drive the vehicle if you have alcohol in your system. So you'll have to, any vehicle that you own or operate. Okay, any vehicle that you own or operate, you can't drive it until you blow into the system and the system. If you don't have any alcohol in your system, then the vehicle will start up. Yeah, it should crank every time. That's right. All right. So, Ms. Daigle, you're gonna follow the bailiff. And yeah, no, they'll be able to give you all of that information at the Jefferson County Jail. The bond is just set at $750. With a bond, with a surety bond, you won't have to pay them. They can give you that information. Okay. Don't have, it's not a cash. I'm not setting it at $750 cash. I'm just setting it at a $750 bond. Okay. All right. So just follow the bailiff. All right. Yeah, he has to. Yeah. Okay. All right. You have a blessed day. Yeah. What's that new case number?
It's a 330648.
Okay. We're in session in two cases. First case is cause number 330154. Second case is cause number 330648. Both cases are styled the state of Texas versus Maisha J. Carter. Ms. Carter, is that your full name? Ms. Carter, would you please raise your right hand? Ms. Carter, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Carter, you may put your hand down. How are you doing, Ms. Carter? That's good. Ms. Carter, you're here represented by your attorney, Ms. Marva Provo. Ms. Provo, how are you doing? That's good. Ms. Provo, do you waive a record in Ms. Carter cases? Ms. Carter, I have before me in cause number 330154 and the information that alleges that on or about June 17 of 2021, while you're in Jefferson County, Texas, that you committed to Class B misdemeanor offense of theft. Ms. Carter, do you understand what you've been charged with? And to this charge, Ms. Carter, how do you plead? Guilty, not guilty, or no contest? How do you plead? Guilty, not guilty, or no contest? Now, Ms. Carter, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Okay. Ms. Carter, I have before me a document that is titled the misdemeanor plea admonishment. Ms. Carter, do you recognize this document? On page 2 of the same document, Ms. Carter, there's a set of initials on the second line next to a box that says check no contingency, which means no contest. Did you place your initials on this document? On page 2 of this same document, Ms. Carter, there is a signature above the line that's titled Defendant. Is this your signature? And on the next document, which is titled the Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? Is this your signature on this document? There are two boxes that are checked at the top of this document. The first box just checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that? The second box states that you're waiving your right to an appeal. Do you understand that? You have the discovery certification? Oh, here it is. Ms. Carter, also have another document that is titled the discovery certification. Do you recognize this document? Yes. Is this your signature above the line that's titled Defendant? Yes. Ms. Carter, now prior to signing initially all these documents that I've just mentioned, did your attorney, Ms. Provo, go over these documents with you? Yes. And did you read and understand everything in these documents? Yes. And is everything in these documents true and correct to the best of your knowledge? Yes. State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, would you also like to offer State's Exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Any objections? No objections. State's Exhibits number 1 and 2 are admitted. Ms. Provo, you advised and counsel Ms. Carter. Is there any evidence that she's currently mentally incompetent to stand trial? No. Ms. Carter, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation? Yes. Has he provided full, effective, and competent legal representation? Has she provided full, effective, and competent legal representation? Okay. Ms. Carter, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. And I will also find that your pleas and waivers was freely and voluntarily given. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
1 year deferred adjudication, $400 fine, 20 hours community service, also a theft offender class. And the state is going to dismiss cause number 330648 in consideration for pleading state.
Okay. Okay. Ms. Carter, the state is offering that you serve 1 year deferred adjudicated probation. During this 1 year probationary period, you'll be required to pay a fine of $400 plus court costs. And the court cost is $337. The total amount of the fine and court costs is $737. Ms. Carter, you also be required to pay a probation fee of $60 each month, a urinalysis fee, $15 each month. And you will be required to reimburse the court-appointed attorney's fees of $250 to Jefferson County. And your total monthly installments that you will be required to pay for this case is $165 per month. Ms. Carter, will you be able to pay the $165 per month? Okay, now, Ms. Carter, let me do this. Look at that paperwork. Oh, here it is. Where's her? Oh, okay. Are you getting the cash bond back today? How much is that cash bond?
500.
500? Well, let me do this here. Let me see her affidavit as well. Are you saying with that $500 cash bond back, you won't be able to pay the $165 per month? That's what you're saying?
Oh, I can pay the 165.
Oh, that's what I was asking you.
Yeah, I can pay that money.
Oh, okay. Strike that. Okay. So you will be able to pay the $165 monthly. Okay. Now, you'll also be required to perform 20 hours of community service, and you will participate in a theft class as a condition of this probation, and the state will dismiss cause number 330648. Now, Ms. Carter, do you understand? Well, also, you would have to adhere to the other standard terms and conditions of this probation. Ms. Carter, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Ms. Carter, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Carter, if you successfully complete the probationary period, this case will be dismissed. It will not appear on your record as a conviction, and you may qualify for a non-disclosure. You can talk to your attorney, Ms. Provo, about the non-disclosure. She's quite competent in these matters. Now, Ms. Carter, stand on the X next to your attorney. You're gonna follow the directions of our clerk. And after you finish following those directions, you'll be given a copy of the dismissal in cause number 330648. And once you get everything, you'll be free to leave, and you have a blessed day.
Okay, would you write them in the blue square?
Yes, and yeah, you have to sign that. Once you finish.
In your honor.
No, Miss.
I'm sorry, I tried to tell him too about the warrant.
That's what I was gonna say, yeah. Make sure you keep that judgment with you, that you're gonna be given. Because if you get stopped by the police, you can just show them that. Actually, it's the dismissal. That's the case that's being dismissed, right? It's the dismissal that you need to show them, because that warrant number was gonna be the same number of your case number. Okay, and the reason why we're saying that, because it just takes a little time for the warrant to be taken out of the system. So you need to have that with you just in case if you get stopped.
Okay, just sign that black box right there, and you won't be able to see it. Greg, you've never recorded during the further communication or? And further swear everything else is same, except for this case, which is being dismissed. And the directions to probation are on the top, and these are the documents. That you just take on. Close for lunch in about 10 minutes. They open back up at 1:30. Yeah, that's the one. Okay, before you go to probation, take that tax bond paper and go down on the first floor in the county clerk. You told her about it.
It's taking a while to come on. All right. All right. All right, Sandy, you have a blessed day. Do you have Ms. Savoy's waiver and explanation on Savoy? She just did it. She just did one today.
It's a paragraph.
Yeah.
Do you have it? I think I handed it.
Oh, you mean you gave it to me?
Yeah, I think yes. Yeah. Yeah. Ariana Savoy. Okay, this is cause number 330038. Case of style of state of Texas versus Ariana Savoy. Ms. Savoy, would you please raise your right hand? Ms. Savoy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? How you doing, Ms. Savoy? You may put your hand down. How are you doing? Okay. Now, Ms. Savoy, I have before me an information that alleges that on or about May 14 of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault. Do you understand what you've been charged with? And to discharge, Ms. Savoy, how do you plead? Guilty, not guilty, or no contest? Not guilty? Okay. So, okay. Well, let me hold on, wait a minute, Mr. Savoy. he does, the gentleman over there represents the state. He does not represent you. Okay. You're representing yourself. So at this time, what I'm going to do, I'm going to reset this case. Okay. Because obviously you're maybe a little confused or something of that nature. And so we're not going to go through with the plea on this case. Mr. Boyd, you need to, what we're going to do is reset your case. Let's reset our case. In the meantime, I know that you said that, initially you wanted to hire an attorney, then you didn't go and talk to no attorneys for some, and then you said you wanted to represent yourself. And so you get up here and then you don't know what you want to do. So what we're going to do, we're going to reset your case. All right. Now, Mr. Boyd, you could still, well, obviously you don't qualify for a court-appointed attorney, but if you decide you want to hire an attorney, you still can do that. Okay. Or if you still want to represent yourself, you can do that. Okay. So at this point, Mr. Boyd, the court is not going to go along with a plea bargaining agreement at this time because it seems as though you don't know what you confused. I don't know what the deal is, but at this time, this case is going to be reset. The court is not going to go forward on a plea bargain on this case today.
Okay.
So we're going to reset your case, stand on the X in front of the court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. Okay. And
It's 330.
that was started. Court is back in session for the court's announcement docket. We're in session at cause number 329384. Case of style of state of Texas versus Brooke Renee Stevenson. Stevenson was scheduled to be in court this morning for the court's announcement docket at 9 a.m. on today's date of October 6th of 2021 at or about 9 a.m. The court bailiff called Brooke Stevenson name at the courthouse door. Brooke Stevenson did not answer. Brooke Stevenson has not appeared in court since the court's been in session. The time now is 12 o'clock noon. And Mr. Bailiff, would you please call the name of Brooke Stevenson?
Yeah, well, she's standing here trying to reset her case. I don't want her to reset it until it's all done.
Okay, Brooke Stevenson's name was just called again by the court's bailiff, and Brooke Stevenson did not answer. A reasonable time has passed to give Brooke Stevenson an opportunity to appear in court, and she has not appeared in court. State, do you have a motion?
Yes, Your Honor, state will move for a bond forfeiture.
That motion shall be granted. Warrant shall be issued for the arrest of Brooke Stevenson, and her bond shall be forfeited in clause number 329384. And this will conclude the calling of the court's announcement docket which was scheduled at 9 a.m. on today's date of October 6th of 2021 in County Court at Law Number 2 of Jefferson County, Texas, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.